Hi friends, myself Advocate Shahid Ali Ansari. Today I would like to have a discussion with you in respect of one of the important and pivotal judgment of the Honorable High Court of Bombay, which is connected with Section 65 of the Indian Evidence Act. We know that according to Indian Evidence Act, the parties to the trial are required to submit or adduce the primary evidences to prove their case. However, sometimes the primary evidences may not be available. For example, the primary might have been lost or destroyed, or it may be in the possession of opponent party, or the primary evidences cannot be brought to the court so easily. And because of this reason, the parties have been given, the litigants have been given right to adduce these secondary evidences. Legislature has provided Section 65 of the Indian Evidence Act, which says that the parties to the litigations can submit or adduce or produce these secondary evidences if original are not available. There are some situations wherein there are some conditions which, if that conditions are satisfied, then and then only secondary evidences can be submitted in the court of law. For example, the original is in existence and the same has been executed by the parties or executants. Second number, the original have been lost, misplaced or destroyed, or the same original evidences cannot be so easily brought in the court of law. Third, the secondary evidence is the true copy of the original. If these three things are satisfied, if are available, then only secondary evidences can be lead or can be adduced in the court of law. However, the practice going on in the trial court is very wrong, which has been very well observed by the Honorable High Court of Bombay in a judgment KARTIK GANGADHAR versus NIRMALA NAMDEV WAGH in writ petition number 11151 of 2017, wherein the Honorable High Court has observed that the trial court is insisting upon to all the parties to make an application or to present an application seeking the permission of the court to lead these secondary evidences, which in fact is clearly wrong in the opinion of the Honorable High Court's judgment, because such a permission is at all not required, or such a permission is not required to be obtained to adduce these secondary evidences. It is the matter of right of the parties to adduce or produce the secondary evidences in the court, provided that the conditions under Section 65 are satisfied. Once it is established by the parties that the original have been lost or destroyed, or it is in the possession of opponent, or the same cannot be brought in the court of law so easily, and the original is in existence and same has been executed by the executants, and the third one, the secondary evidence is the exactly true copy of the original. If these three conditions are satisfied, then there is no another condition which can be put by the court to the parties to adduce these secondary evidences. However, practice goes on in the trial court that court insists upon the parties to make an application to seek or to take permission of the court to submit the evidences. Court has observed, Honorable Court has observed that no such permission is at all required, because it is not contemplated in Section 65 of the Evidence Act. Nowhere it is stated in the Indian Evidence Act that such a permission is required. Therefore, this practice adopted by the court is against the law and against the settled judgment of the Honorable High Court of Bombay, which have been delivered by earlier Honorable Judges. In the opinion of Justice Patel, he has observed that it is with a great regret that I note that the trial court continue persistently to ignore the settled law and binding precedents on the question of leading secondary evidences. For reasons that are entirely unclear, there seems to be an insistence on filing an application for permission to lead secondary evidences. This is simply wrong. And the Honorable Justice Patel has also relied on one of the judgments delivered by the earlier judges, Honorable Justice Wajibdar, who in a case of Indian Overseas Bank versus Truckle Textile Industries has stated the same thing, that neither the permission is desirable nor it is required. It is not contemplated in the statute. It is against the jurisprudence and the settled law as well as the judgment of the High Court that asking such a permission by the court cannot be justified. Therefore, the parties are not required to take the permission of the court. It is their matter of right to submit the secondary evidences if they have satisfied three conditions. What the Honorable Justice Wajibdar has observed in Indian Overseas Bank, I would like to read the important paragraph here. It is settled law that no such application is at all maintainable or even desirable. In the context of chamber summons for such a leave filed on the original side, held that such a chamber summons is not just unnecessary, it is misconceived. He said it was neither necessary nor desirable. It is always open to the party to lead secondary evidences before the trial court, recording evidences or hearing the matter without having to file such an application. This is stated as well as the order passed by one of the trial court came to be quashed and set aside in the present writ petition number 11151 of 2017 by the Justice Patel, wherein he said that no such a permission is at all required and it is adopted by the court and such a procedure is not contemplated under the Indian Evidence Act. Nowhere it is stated. So hope that the trial court would follow the present judgment and hope that the trial court will not insist upon the parties to file an application seeking its permission to lead the secondary evidences. It is matter of right of the parties to lead the secondary evidences, provided that the three conditions mentioned in section 65 are satisfied. And what is secondary evidences have already been given or explained in section 63 of the Indian Evidence Act. Therefore, the conclusion is that parties are not required to make an application to lead the secondary evidences. It is matter of their right, and making such application is not covered or contemplated by the law, and it is against the law. Insisting by the court to litigant to submit such application will be against the law, against the judgment and against the jurisprudence. Therefore, no such applications are required to be submitted by the parties. Hope that you have understood this judgment. I wanted to explain this judgment with you and I have covered the important aspect of this judgment. Advocate Shahid Ali Ansari, thanks to hear me.